I called my attorney, Simone 80, before I called anyone else. Simone and I had worked together for 4 years on Meridian's corporate legal matters, contracts, IP, one prior employment dispute, and I trusted her the way you trust someone who has read every document you have ever signed and still returns your calls on weekends. She read the complaint and was quiet for a long moment. Then she said, "Nadia, this is aggressive, and it is almost entirely without merit. But almost is the word we need to work with." Their claim rested on 3 pillars. First, that my father had provided foundational business guidance and intellectual framework during Meridian's formation, and that this amounted to an uncompensated contribution. Second, that a $3,500 check my father had written to me in 2014, a birthday gift I had deposited, and in their version, used for business expenses, represented an undisclosed equity investment. Third, that family property, specifically a storage unit registered in my father's name that I had used briefly in 2015 to store equipment during an office transition, represented an ongoing in-kind contribution to my business operations for which they were owed compensation. I stared at the ceiling of Simone's conference room. "The $3,500 was a birthday check," I said. "There's a card. It says, 'Happy birthday, love, Dad.'" "I know," Simone said. "We'll need the card." I had the card. I had kept it, not for legal reasons, but because it was the only birthday card my father had ever signed with the word love. I had held on to it with the kind of careful sadness reserved for exceptions that prove the rule. We spent the next 14 months building our case. It is easy, in retrospect, to make that period sound clean. The woman gathering her papers, the executive preparing her defense, the daughter quietly building the record that will one day save her. But that is not what it felt like living inside it. In reality, it was 14 months of carrying a lawsuit filed by my own parents through every workday, every family obligation, every quiet hour that should have belonged to something else. Meridian was navigating a major contract renegotiation during that stretch. We were expanding our Dallas operation. I was hiring for 3 new senior positions at the same time. I had a company to run, 214 people, whose livelihoods depended on my ability to keep making sound decisions, while the static of my parents' lawsuit hummed in the background of every meeting. My operations manager, a former military logistics officer named Kwame Asante, knew something was wrong within the first month. He did not ask. He simply started scheduling our weekly check-ins for Friday afternoons instead of Monday mornings. "So you have the weekend to process anything heavy?" he said, without ever naming the heavy thing he had clearly noticed. That small recalibration, unrequested and unexplained, kept me functional through more Fridays than I can count. Desiree, who by then had become Meridian's head of client relations, took over 2 of my scheduled client dinners without being asked, citing a scheduling conflict she and I both knew did not exist. Her father, Gerald, when I told him about the lawsuit over the phone, was quiet for a long time before saying, "You have every document you need. I know you. You kept everything." He was right. I had kept everything. My brother Marcus called me 6 weeks after the lawsuit was filed. I want to give him the credit he deserves, and also the truth. He called to say he thought our parents had made a mistake. He also asked whether there was any version of this that could be resolved without going to court. He was not asking on their behalf, he clarified. He was asking because he understood, better than most people, how much damage a public proceeding could do to a family that had spent decades maintaining a careful image. I told him I had not filed this lawsuit. I told him I would defend it completely. I told him I loved him, which was true. And then I told him I could not keep having this conversation, which was also true. 2 days later, he sent me a text that said, "Whatever happens, I'm your brother. That's not on the table." I saved that text. I have looked at it more times than I ever planned to. The trial was set for a Thursday in May. I wore a charcoal blazer over a white silk blouse and pearl earrings my maternal grandmother had given me at my college graduation. The same grandmother who had, without my parents' knowledge, quietly told me the year before she died that she believed in me more than I knew. I carried a single leather document folio. I arrived at the Franklin County Courthouse at 7:45 for a 9 o'clock start. I sat in a conference room with Simone and her associate, a meticulous young attorney named Brandon Chu, who had spent 3 weeks doing nothing but cross-referencing every financial record we possessed against the claims in the complaint. Brandon had found something in that process, something we had not initially been looking for. I will get to that. My parents arrived with Douglas Fitch at 8:50. My mother was wearing the navy dress she wore to important occasions. My father was in his best suit, the dark one with the faint pinstripe he had bought for Marcus's medical school graduation. They did not look at me in the hallway. The courtroom was smaller than courtrooms look on television. Pale wood paneling, fluorescent overhead light sharpened by narrow windows, an American flag beside the bench that hung slightly crooked. Judge Helen Marbury presided. She was in her mid-50s, efficient, and carried the particular manner of a judge who had heard too many cases built on family grievance, dressed up as legal principal. She was not hostile. She was not sympathetic. She was reading. Douglas Fitch gave his opening statement with the confidence of a man who had decided the case was already his. Everything this young woman owns was built on stolen family capital. My father nodded at strategic intervals. My mother kept her hands folded in her lap with the careful stillness of someone practicing composure. Then Simone stood. Her opening statement was specific, organized, and brief. She laid out the timeline of Meridian's founding with the precision of a surgical incision, the date of incorporation, the source of initial capital, the progression of revenue, the complete absence of any financial contribution from the plaintiffs. She did not editorialize. She did not need to. Then Judge Marbury turned to me and asked whether I had anything to add before we proceeded. I stood. I adjusted my jacket. I looked directly at Douglas Fitch across the aisle, and I said, "Exhibit 1. The court reporter stopped typing. She looked up. Fitch blinked. His associate leaned forward. Simone placed the first document in front of the judge. Exhibit 1 was the original loan agreement between myself and Gerald Washington, dated March 14th, 2013, in the amount of $12,000, bearing both our signatures and the notarization of a Columbus area notary public. Attached to it was the repayment ledger, fully annotated, showing every payment made between April 2013 and September 2014, totaling $12,840, principal plus agreed interest. Attached to that was a signed letter from Gerald Washington confirming that the loan had been repaid in full and that he retained no equity, no financial claim, and no outstanding interest in Meridian Transit Solutions. Exhibit 2 was Meridian's original certificate of incorporation, filed with the Ohio Secretary of State's office on March 28, 2013. Sole incorporator, Nadia M. Okafor Brennan. 0 co-founders. 0 listed investors. Exhibit 3 was the birthday card, a standard Hallmark card with a cardinal on the front, signed in my father's handwriting. "Happy birthday, sweetheart. Love, Dad. $3,500 for whatever you need." No mention of investment, no mention of business, no terms, no equity, no written agreement of any kind. Exhibit 4 was my mother's own handwriting. A letter she had sent me in 2015, which I had kept in the same box as the birthday card, in which she referred to my business with the phrase, "your little company," and expressed hope that I would eventually find something more stable. That was not the language of an investor. That was not the language of a contributor. That was the language of dismissal, preserved in ink, dated, signed, undeniable. Exhibit 5 was a property records document showing that the storage unit my father had registered in his name, the one they claimed represented a continuing in-kind contribution, had been listed for sale in December 2015 and transferred to a new owner in January 2016. It had not been in my father's possession for 8 years. The claim that it represented an ongoing contribution was not merely weak, it was factually impossible. Douglas Fitch objected to Exhibit 3 on grounds of relevance. Judge Marbury overruled him with the brief efficiency of someone who had already understood exactly what she was looking at. Then Simone said, "Your Honor, with the court's permission, the defense would like to present Exhibit 6. This was what Brandon Chu had found during those 3 weeks of cross-referencing. Exhibit 6 was a filing with the Ohio Secretary of State from 2019, showing the incorporation of a company called Clement O. Logistics Advisory, LLC, a consulting firm registered in my father's name, which had in its first 2 years of operation invoiced 3 separate clients using language, service descriptions, and operational frameworks that Brandon had traced, document by document, to internal Meridian operational manuals I had authored between 2015 and 2017. My father had not stolen my company, but he had, it appeared, borrowed liberally from the documented operational methodology I had developed to build one of his own. A small one, a quiet one, one that had generated less than $200,000 in total revenue across 4 years and apparently had not thrived. No attribution, no acknowledgement, no conversation. He had never once mentioned to me that he had done it. The room went very still. My father looked at the document for a long time. Then he looked at his attorney. Fitch leaned over and whispered something. My father said nothing. My mother's hands were still folded in her lap, but they had tightened. Judge Marbury reviewed Exhibit 6 for 3 full minutes. Then she looked up at Douglas Fitch and said, in the measured tone of a judge determined to remain patient for exactly as long as the record required, "Counsel, I'd like to understand the plaintiff's theory of the case in light of this exhibit." Fitch stood. He said the exhibit was circumstantial. He said any similarity in language was coincidental. He said his clients had decades of business knowledge and every right to apply their general expertise. Judge Marbury repeated the phrase back to him. Their general expertise. Fitch said, "Yes." "Your Honor." The judge looked at him for a moment that lasted slightly longer than necessary. "The same expertise," she said, "that the complaint alleges was so uniquely foundational to the defendant's company that she owes them its entire value." Fitch had no answer for that. He attempted one. It trailed off. Court recessed for lunch. I ate a sandwich in the conference room with Simone and Brandon. I was not hungry. I ate it because Simone had brought it, and because the afternoon session required me to be functional. Somewhere in the logistics industry, I had learned a rule that applied just as well to survival as it did to shipping. You fuel the operation regardless of how you feel about the fuel. Simone said she thought Judge Marbury was going to rule for us comprehensively. Brandon said he thought Douglas Fitch might try to withdraw before she did. I asked, "What happens to my father's LLC?" They looked at each other. "That is a separate question," Simone said carefully. "One thing at a time." The afternoon session was shorter than the morning. Fitch called my father to the stand. Clement Okafor testified with the same settled authority he brought to everything. His tone never wavered. His posture never shifted. He said he had provided guidance. He said he had offered his knowledge. He said the $3,500 check had been intended as a business investment, and that in our family these things are understood without paperwork. Simone's cross-examination lasted 6 questions. The first was this: Mr. Okafor, in March 2013, did you decline to provide a $12,000 loan to your daughter for the purpose of starting Meridian Transit Solutions? My father paused. Then he said, I advised against the venture at that time. Simone did not move. Did you decline to provide the loan? Yes or no? Yes. No further questions on that point. The second question concerned the storage unit described in Exhibit 5. When did you last have legal ownership of that property? My father looked at Fitch. Fitch could not help him. January 2016, I believe. So you had no ownership of this property for 8 years prior to filing this claim. The use I am asking about ownership, Mr. Okafor. No. The remaining 4 questions addressed the birthday card, the letter my mother had written, and the operational documents in Exhibit 6. My father answered each one in a voice that grew incrementally quieter. It was not collapse. It was settlement. The way a structure sounds when weight is removed from it and the frame finally tells the truth. When he stepped down from the stand, he walked past the defense table. He did not look at me, but for a single second, as he passed, his pace slowed, barely, almost imperceptibly, the way a person pauses at something he cannot bring himself to face directly. I still do not know what to do with that half second. I have thought about it many times since. Judge Marbury issued her ruling the following Tuesday. She dismissed the complaint in its entirety. She found that the plaintiffs had failed to establish any legal basis for their claim of misappropriated capital, that the $3,500 check constituted a gift under Ohio law with no documented conditions, and that the storage unit claim was not only unsubstantiated, but factually incoherent given the property's sale in 2016. She also noted, in language I asked Simone to read to me a second time because I needed to hear it again to believe it, that the court views with concern the apparent pattern of conduct in which the plaintiffs filed claims of significant financial magnitude without evidentiary foundation and reserves the right to consider sanctions pending a review of filings. Sanctions were assessed 60 days later. Douglas Fitch's firm was ordered to pay $43,000 in defense legal fees. My parents were ordered to pay $17,500 in court costs. I do not feel triumphant about the sanctions, I want to be precise about that. There was no satisfaction in the number, no thrill, no clean revenge. There was something else, a kind of exhausted correctness. The way a long equation finally balances and what you feel is not joy, but the relief of verified accuracy. Marcus called me the night of the ruling. He said he was sorry. He said it simply, without qualification, without trying to explain exactly what he was sorry for, which told me he understood that the list was too long to itemize. I appreciated that. I told him I was okay. He said, "You are not, though." I said, "No, but I will be." We talked for 40 minutes about other things. His daughter's first word. A documentary we had both seen. The way the Columbus weather had been strange that spring. It was the longest conversation we had in 3 years. It felt like finding a room in a house you thought you had been locked out of, only to discover it had always been unlocked. I do not know what happens with my parents. I want to be honest about that in a way that resists the clean resolution. Stories like this are supposed to provide. My father has not contacted me. My mother sent a text message 2 weeks after the ruling that said, "I hope you're well." I read it 7 times and did not respond. I am not sure what a response would be. I am not sure what that text even was. What I do know is this. The $47 million is mine. Earned, documented, defensible. 14 years of supply chain routes and cold storage logistics and pharmaceutical contracts, and 214 people showing up because the operation is sound. My father did not build that. My mother's dismissal did not build that. The birthday card did not build that. Gerald Washington's faith built some of it. Desiree's loyalty built some of it. Taryn's willingness to work for equity in a company that had not proved anything yet built some of it. Kwame's quiet Friday afternoon reschedules built some of it. And I built the rest. I am in my office right now. A good office with a window that faces east, and there is a cup of coffee going cold on my desk because I got absorbed in a contract review and forgot it was there. In an hour, I have a call with our Toronto operation about a new pharmaceutical client. After that, I am having dinner with Desiree, who is 3 months pregnant with her first child, and wants my advice on maternity leave policy, which I will give her, and then I will revise our company policy to reflect it, because that is how you build something that lasts. My grandmother's pearl earrings are in a small dish on my desk. I wore them to court. I wear them on days that matter. Today matters. Most days do, when you are paying attention. The 2 words were Exhibit 1. And what I meant was this. I kept everything. I kept everything. And I was ready. I had been ready for longer than they knew to look. That is what I said with 2 words in a courtroom in Columbus, Ohio, on a Thursday in May. The court reporter stopped typing because she needed to see what came next. So did I. If this story stayed with you, stay with the channel. There are more stories where the record speaks, where silence breaks, and where the truth arrives fully documented.